Hi, thank you. Thank you for coming to today's program. I hope I'm not too loud here. Thank you for joining us for the Federal Society's Practice Group's presentation of municipal bankruptcy and pension reform, A Way Out. We're going to have a presentation of a paper today and some commentary on that, and eventually open it up to you guys for questions and questions. We really don't want comments. Just questions. We want comments from our experts, not from the peanut gallery. Today, presenting his paper, we have Professor David Skeel. Professor Skeel is the Samuel Arsht Professor of Corporate Law at the University of Pennsylvania Law School and is currently a visiting professor of law at NYU Law School for this semester. He has written numerous books and articles on bankruptcy and corporate law. He has been awarded numerous awards for his teaching and for his upper-level teaching as well, which means that not only is he smart, but he can convey it well, hopefully to you all. And he will be presenting his paper, which is entitled, Can Pensions Be Restructured in Detroit's Municipal Bankruptcy?, which deals with issues of bankruptcy law, constitutional law, and particularly takings and contracts clause law, as well as some of the specifics of Michigan's constitutional and statutory structures dealing with their municipalities. Commenting on this paper will be Professor Thomas Merrill. He is the Charles Evans Hughes Professor of Law at Columbia Law School, my alma mater. He has written widely in issues of property administrative law, and presumably therefore will be focusing primarily on the property aspects of this and whether pensions are property and how can they be restructured. Prior to his current professorship, he started out clerking for Judge David Bazelon of the U.S. Court of Appeals for the D.C. Circuit, subsequently clerked for Harry Blackmun at the U.S. Supreme Court, was Deputy Solicitor General for a stretch, and then taught at Northwestern and Yale Law Schools. We are glad to have them both, and I will now turn it over to them and try to be as unobtrusive as possible. Professor Skeel.
Thanks, Erik, and thanks, Dean and Will, for setting this up. And I think I'm thanking Tom for his comments, but maybe I'll wait and hear the comments before I decide whether thanks are in order or not. So the context of this is I have been writing about municipal bankruptcy and whether states ought to be able to file for bankruptcy for the last several years. And one of the key issues, both with municipal bankruptcy and with state bankruptcy, is whether pensions can be restructured, because they're a huge part of the problem in many of these contexts, the big problem. And so in conversation with Dean over a few weeks last summer, when Detroit filed for bankruptcy, we agreed that I would write a paper, a white paper, just trying to lay out the issues, the arguments pro and con, and reach a conclusion about whether pensions can be restructured in bankruptcy. And so that's what this is. And it's an argument that I believe they can, in fact, be restructured in bankruptcy, and I'll tell you why and how. It's a very controversial issue, obviously. It's also it's kind of a close call. There are good arguments on both sides of it, but in my view, the stronger arguments weigh in favor of the conclusion that pensions can be restructured. So what I'll do in hopefully like about 15 minutes, I'll try not to go beyond that, is four things really quickly. Just briefly flag the extent of the problem and how we got here. This will be familiar to you all. Then second, turn to the heart of what I have to say, and that is addressing the question whether pensions can be restructured. Third, I'll talk about three of the major arguments against restructuring pensions, three of the major arguments that they can't be restructured. I talk about more in the paper, and I'm not going to get into all the nitty-gritty detail in these remarks. If people want to, we can go there. I'll just use our conversation as a guide. But the third thing is what are the arguments against restructuring them, and then finally, what would the benefits of restructuring be? If they can be restructured, it seems to me that there are a couple of pretty important benefits. So extent of the problem, y'all have heard these numbers and variations on them. The estimate people are throwing around with Detroit as to its pension underfunding is $3.5 billion out of Detroit's $18 billion of debt. That $3.5 billion it's kind of a back of the envelope estimate, but it may well be understated rather than overstated. Chicago, its pension underfunding, roughly $30 billion, I think, right now. Illinois itself reports an underfunding of $97 billion. A more accurate number would probably be closer to $200 billion. So when we're talking about pensions in general and sort of focusing on Detroit, in the back of our mind should be Chicago, my city, Philadelphia, and Illinois. And you could go on from there, but those are a few of the cities and the state that are in the worst trouble. So how did we get here? We got here in part because of the Great Recession, but it is important to keep in mind, as most people recognize, that the pension problem is not just a recession problem. As Richard Ravitch and Paul Volcker said in a report they did on municipal and state problems about a year ago, it's a structural problem. It's a problem that is not going to go away when the economy improves. It is a situation where a number of municipalities, at least one state, are in a situation where they may not be capable of paying the pension promises that they have made. And this is, in my view, in no small part due to a bargaining breakdown in the bargaining over public pensions. Cities, when they bargain over their pensions with bargain with public employees over their pensions, are not or have not been bargaining on an arm's length basis. The city employees and the public employees are really both on the same side of the table, and I think that's part of why the problem has gotten as severe as it has. So the core of what I want to talk about, and that is the question, can pensions be restructured? And I'm going to be talking about restructured in bankruptcy. There's a lot of stuff that's going on outside of bankruptcy. A number of states have tried to take steps to restructure their pensions. They've done things like reduced cost of living adjustments going forward, and there's been some success with those efforts. But in most states, it really is state by state, depending on what state law says about pensions. In most states, there are real limits to what you can do outside of bankruptcy. So the big question is, can a meaningful, significant restructuring of pensions be done in bankruptcy? My conclusion is it can, and here is the reasoning that I used to reach that conclusion. The basic idea in bankruptcy is that ordinary creditors are fully protected in bankruptcy to the extent that they have collateral securing the debtor's obligation to them. So if a creditor lends $100 to a debtor and this obligation is collateralized, it's secured by a widget that's worth $70, the normal bankruptcy rule is that creditor is absolutely protected up to the $70, the value of the widget, that's the collateral. Creditor either has to be given the widget or has to be given that value. The creditor has a property right in that widget. But the other $30, the $30 difference between the value of the collateral and the obligation, can be restructured in bankruptcy, and that's a big part of what bankruptcy is about. The core of my argument is really simply an argument that pensions are like other obligations. To the extent that a city or a state has set aside money, funding for the pensions, as they are supposed to do, and in fact, Michigan's Constitution purports to require that the money be set aside, those retirees are fully protected, but to the extent the funding is not there, it is an unsecured obligation like other unsecured obligations and can be restructured. So that's the core argument that I make in the paper and that I've made in some of my writing elsewhere. So what are some of the arguments against restructuring? What are some of the arguments that pensions cannot be restructured in bankruptcy? Let me mention three, and I'm mostly going to leave one of them, which is the takings argument, to Tom, in no small part because Tom is more of an expert on this than I am. But let me go through three of the main arguments that pensions cannot be restructured in general and in particular can't be restructured in Detroit. So the first argument in Detroit is that the Michigan Constitution has a provision, it's Article 24, Section 9 of the Michigan State Constitution, that explicitly says pensions cannot be impaired. And so the argument is, Michigan Constitution says you can't do anything with these pensions, therefore you can't do anything with the pensions. This is not a silly argument. I'm not 100% I'm right, but I am of the view that that argument ultimately loses and that the pensions can be restructured. Why does that argument lose? Well, one reason it loses is that it seems to me there's a bit of a misunderstanding as to what the point of that constitutional provision was. The provision was enacted in 1963 in Michigan. It was enacted at a time when pensions were considered to be gratuities. A pension promise was considered to be something that the city or state could just change its mind about, and it was not a contractual obligation. So the first thing to note, in my view, is that this constitutional provision, the primary purpose of it was to make a contractual commitment for the state to say, we're not going to just suddenly decide we changed our mind about the promise we made to you. It's not an argument about priority. So it's an argument about the nature of the promise, that it is a contractual promise. But in my view, it's not an argument about whether the pensioners actually get 100 cents on the dollar, of what their priority is in the event of a crisis, because that wasn't what Michigan was thinking about. And in fact, the second half of this provision is designed to deal with that priority issue. The second half of the provision says you got to set aside the money each year to pay your accruing pension obligations. That's where the priority comes into play. If Detroit had funded its pensions like it was supposed to, this problem would have disappeared, and nobody would be questioning whether the obligations are protected in bankruptcy. So that's part of that's one shortcoming of the Michigan constitutional argument. The other shortcoming is simply that bankruptcy, municipal bankruptcy, which is Chapter 9 of our bankruptcy laws, is enacted under the constitutional power Congress has to enact bankruptcy laws. That is federal law. Federal law trumps state law, even state constitutional law. There's no distinction between state case law, state normal statutory law, and state constitutional law. Bankruptcy provides for restructuring. Bankruptcy is federal law. Bankruptcy trumps state law. So that's the first argument against restructuring. The second argument is a contracts clause, a U.S. contracts clause argument. And the argument is that Congress can alter an existing contract, such as these pension obligations, but the state can't alter those obligations. So the contracts clause of the Constitution says no state can interfere with contractual obligations. Congress can, states can't. The bankruptcy laws, the municipal bankruptcy law is federal law, so it looks like it might be okay. But the contracts clause argument is really what municipal bankruptcy law is doing is facilitating a violation by the state or by the city of its contracts. That is not permissible. That is, in effect, an argument that municipal bankruptcy is unconstitutional. And this was hashed out in the 1930s. In 1936, the Supreme Court, in a case called Ashton, said municipal bankruptcy is not constitutional. It is unconstitutional. 2 years later, after a switch in personnel on the Supreme Court, 1938, in a case called Beacons, the court said municipal bankruptcy is constitutional. Not much difference in the two laws the court was dealing with. The real difference was on the court. So this second argument is an argument, and the Detroit unions are already making it, that municipal bankruptcy is simply unconstitutional, that it's a violation of the contracts clause. I think this argument loses. I think because of the explicit bankruptcy power that Congress has and some of the protections that are provided for in the municipal bankruptcy laws, this argument loses. But again, it's not a silly argument. It is not inconceivable that the Supreme Court would strike down municipal bankruptcy. I don't think they will, but it's not inconceivable. Final argument I want to note is that there is a provision in Chapter 9 itself, in the municipal bankruptcy laws themselves, that Detroit's retirees have pointed to as making it impossible to restructure pensions. And so the argument is, even if you theoretically could restructure pensions, there's a provision in Chapter 9 in the municipal bankruptcy laws that takes this off the table. And what the provision says is that a plan cannot be approved if what it does is, quote, prohibited by law. So you cannot approve a restructuring if what that restructuring would do is, quote, prohibited by law. The argument is Michigan prohibits interfering with pensions by law, therefore a municipal bankruptcy cannot interfere with pensions as a matter of municipal bankruptcy law itself. I also think that this argument loses, and I think the reason that it loses is pretty clearly what that provision is intended to apply to is the obligations after they are restructured. That provision is not intended to prevent a restructuring of obligations. Prohibited by law does not mean that an obligation that couldn't be restructured under state law also can't be restructured under Chapter 9. If it did mean that, Chapter 9 would be pretty much completely gutted because the contracts clause would prohibit restructuring any obligation. I think what this provision really means is that once you've restructured the obligation, the terms of that restructuring have to be consistent with state law. So you can't restructure the obligations to do something that state law wouldn't allow. And there's one case on this, and what that case involved was a state law that said you cannot restructure bonds. It also said the bonds can't provide for a payout that's less than 100 cents on the dollar. And what the court said is, well, you can restructure the bonds in Chapter 9, but what you can't do is give the bondholders new bonds that would allow for a payout that's less than 100 cents on the dollar. So if the bonds originally promised $100, you restructured them so that they now promise $70, you couldn't have a provision that says the state or the city in the next six months has the right to buy them back for $60. Once you've restructured them, you have to pay them in full. The general idea, again, being that what this provision applies to is the restructured obligations going forward, not to the restructuring itself. If it applied to the restructuring itself, Chapter 9, again, would be gutted. And it's possible that the Supreme Court would conclude Chapter 9 is gutted, but I think it's kind of unlikely. Okay, so that's the basic argument that pensions can be restructured. I've given you three of the strongest arguments against it, no one of which is silly. I think, in particular, the first two, I think, are quite credible arguments. I think they lose in the end. If I'm right about the restructuring, what are the benefits of this? Well, there are two kinds of very, very significant benefits. The first is that cities, possibly down the road states, currently states can't file for bankruptcy, but hopefully someday they will be able to. Cities now would be able to restructure pensions. A number of cities, if they cannot restructure their pension obligations, it's just hard to see how they're going to get out of the mess that they're in. If they can't do anything about their pensions, cities like Detroit, Chicago, to some extent Philadelphia, hard to see how they ever right their financial boat. So that's the first benefit. The second benefit is what we law professors like to call the ex ante benefit. The benefit not now that we've got this mess, but the benefit before we ever get into this mess. And the benefit there is that if it's possible that pensions can be restructured, I am a public employee, I'm going to look a little differently at those pension promises. I'm going to look a little differently at whether my city is actually setting aside the funding it's supposed to be setting aside. I'm going to be hesitant about accepting in my contract pension promises that are unrealistic. I am going to care a lot more about whether those pension promises are actually funded or not. So in my view, this is one of the rare places where bankruptcy can actually have a positive political effect. A lot of people, when they criticize municipal bankruptcy, their main criticism is bankruptcy doesn't fix politics. Bankruptcy can fix your balance sheet, it doesn't fix the politics. For the most part, that's right, but in my view, with pensions, it's not right. That bankruptcy could actually make our politics better going forward than they are now. Now, I've moved away from what my white paper is about. The white paper is simply, can pensions be restructured or not? And I conclude they can, but I also conclude that it would be a good thing if they could be restructured. So let me stop with that.
Thank you.
Well, I hope you all get a chance to read David's paper. It's quite excellent. It's very succinct, and if you're like me, you'll learn a lot about municipal bankruptcy and what's going on in Detroit from giving it a quick read. I'm going to try to make 7 points, maybe in logical order, maybe not, in response to David's paper. Thoughts that I had, basically, reading through it. The first point I'd make, and David sort of alludes to this in his paper, but I think it's worth emphasizing a little bit, is that the jurisprudence of the Contracts Clause, at least the jurisprudence that has evolved since the 1970s in the state courts, is part of the problem of underfunded municipal pensions and state and municipal pensions, and the financial crisis that our state and local governments are now experiencing. If you go back and look at the original history of the Contracts Clause, you will find not a single mention of public contracts as being what the framers thought they were protecting when they said that no state shall impair the obligation of contract. They were thinking of private contracts, mortgage lending, various types of debts that one private party had to another, and they were worried about state governments interfering with the correct enforcement of those obligations as they were written. It wasn't really until about the 1810s and 20s that the Supreme Court decided that, well, public contracts are also protected by the Contracts Clause. Fletcher versus Peck, Dartmouth College versus Woodward, you may remember some of these names. But even for the balance of the 19th century, there was no sense that public contracts were somehow different from private contracts. They were all covered by the Contracts Clause, and they were all subject to basically the same type of analysis. Then, lo and behold, in the 1970s, which was a period of great fertile imagination with respect to constitutional law, the Supreme Court announced in the New Jersey Trust case that public contracts were entitled to more protection under the Contracts Clause than private contracts were. Private contracts, you can kind of just let the state do whatever it wants to as long as it has a good reason. But public contracts, we're going to scrutinize state impairments of those very closely. And, you know, it's not entirely clear what motivated the court. I have my own theories. I think it was sort of part of the whole entitlements revolution, and public contracts were somehow regarded as an entitlement that needed to be protected by courts. Private contracts, that's just, you know, economic regulation stuff. We don't have to worry about that. In any event, the state courts took the hint and in many cases, with California in the lead, have interpreted the Contracts Clause as it applies to these pension benefits in truly extraordinary ways. So in California and 12 other states, if you take a job with the government, whatever the pension rules and accumulation provisions that are in effect on the day you start work last with you until you quit working, until you retire. So if you get 2% of an additional pension every year when you're hired, and then the state later on decides that's too generous and they want to cut it down to 1%, too bad. the employee that was hired under 2% gets 2% for the rest of his career. This rule, I think, has obviously substantially enhanced the value of public pensions as a matter of constitutional law. And I would strongly urge that if the U.S. Supreme Court can get its hands on one of these cases, a lot of them are based on the Federal Contracts Clause, it would be a good idea to eliminate the spurious interpretation that has evolved in response to the idea that public contracts stand on a higher plane than private contracts. Second point I'd make, David asked the interesting question of will the Supreme Court strike down municipal bankruptcy? No, they will not. If you go back and look at those two cases, David says it's all a switch in time. You know, the FDR appoints somebody to the Supreme Court and the court packing plan, and they all go scurrying for the shelter. Maybe, but I think actually, I think there was a difference between these two statutes. If I understand these cases correctly, the 36 case did not have in its provision a requirement that the state government had to consent to municipal bankruptcy. The state, in fact, had passed a law. Texas had passed a law authorizing municipalities and local governments to file, but there was no requirement in the federal bankruptcy code that the state had to consent. Congress amends the statute to say the state has to consent, and that was the whole rationale that Chief Justice Charles Evans Hughes relied upon in 1938 in saying that this was okay, that basically the state had consented to this, and so any 10th Amendment type limitations went by the boards. You may be aware that more recently the U.S. Supreme Court in 2006 in a case called Central Virginia Community College versus Katz essentially seemed to say that practically all of bankruptcy law can be applied to state governments. They distinguished Seminole Tribe, the case in which the court had said that the Commerce Clause doesn't authorize the Congress to abrogate state sovereign immunity. And in a remarkably originalist decision, or at least purported to be an originalist decision by Justice Stevens, a majority of the court said that the states were put on notice when they ratified the Constitution in 1789 that there was going to be uniform laws of bankruptcy, at least potentially, and that one of the problems that had given rise to this was one state putting somebody in debtor's prison when they'd been discharged in another state, and so this uniform bankruptcy power was understood to eliminate the ability of states to put people in debtor's prison. That's a judgment running against the state, and therefore the Bankruptcy Clause, Article 1, Section 8, Clause 4, does permit Congress to legislate, at least in certain ways, like recovering preferential transfers and so forth against states. So that precedent being on the books, my guess is that combined with Hughes' opinion about consent makes it extremely unlikely that we're going to see municipal bankruptcy declared unconstitutional. The current statute, as I understand it, requires state consent, and Michigan did pass such a statute consenting to municipal bankruptcy. So, does the Takings Clause provide a barrier to municipal bankruptcies? Are these pension holders going to race off to the Federal Court of Federal Claims and get judgments equal to the full value of their pensions once they're chopped down in bankruptcy? No, that's not going to happen. I think there's at least 4 barriers to Takings Clause liability here. The one that's the most interesting, and I'm sure maybe Erik would like to discuss it with me, is, are pension obligations property? In order to have a takings claim, you have to show that your property's been taken. Is a pension obligation running from the state to an individual private property? The benchmarks here are not very great. I'd say the 2 that are most on point are a series of Supreme Court cases holding that Social Security benefits are not property for Takings Clause purposes. They may be for procedural due process purposes, but not for Takings Clause purposes. And another line of cases capped off this last term in a decision called Kuntz versus St. Johns River Water Management Authority, where the court has quite explicitly said that secured debts are property for Takings Clause purposes. So we have these 2 benchmarks, Social Security, and I assume other things like Social Security, Medicaid benefits, for example, Social Security disability benefits, are not property if the government, takes them away from you. And secured debts, liens, mortgages, and so forth are property. You know, David thinks that funded pension obligations are sort of like secured obligations, and unsecured or unfunded are sort of like regular unsecured debts, and maybe he's right about that. But it strikes me there are some differences between even a funded pension obligation and a security interest. A security interest is one in which the debt is secured by specific assets that the debtor has, typically real estate or something like that, or personal property. These pensions, these defined contribution pensions, are backed up by sort of general funds that the state has set aside, or the government set aside, but not specific assets. I think if the court got a hold of this case, they would probably look for some analogy in the common law. The one that sort of strikes me as perhaps appropriate would be a beneficial interest in a trust. Trusts typically have lots of investment assets in a pool, and then the beneficiaries have certain shares in the trust. I can't imagine why this would happen, but if the government decided to somehow take somebody's beneficial interest in trust, I think the court would say, yes, that's property. And I think on that basis, probably they would say that your pension is also property, certainly to the extent it's funded. Second reason why the takings clause is not going to be a problem, I think, is that the takings clause ordinarily applies when the government takes some property and transfers it to somebody else or to the government itself. Some people have said that there's a usings aspect. You have to take for public use. A bankruptcy court is not taking property for the government or for somebody else to use. They're adjusting obligations between debtors and creditors where there's not enough money to pay off all the creditors. It doesn't seem to me that this is the same kind of exercise that the takings clause is designed to handle, and the court might be inclined to say, well, bankruptcy is just per se exempt from takings clause constraints because bankruptcy is not designed to take property and transfer it to some other public use. Third reason, probably no denial of just compensation. You'd have to ask whether or not the pension holder is worse off after the adjustment of the pension in bankruptcy than they would have been if there was no bankruptcy whatsoever. Very likely they're not worse off because if there's no bankruptcy whatsoever, the city's assets would have been dissipated in wrangling over what to do among multiple creditors, and the pension holders would end up with even less money. So that would, I think, there's no just compensation owed because no one's lost anything would be a powerful argument here. Lastly, for those fans of the Tucker Act, the government would have an argument that, at least insofar as we're not talking about per se takings, if there are disputes, factual disputes to be resolved, file your suit with the Court of Federal Claims. It's the forum to resolve this and see whether or not you're owed compensation. Fourth point. Assuming there's no contracts clause problem, David's right that contracts clause doesn't apply to the federal government. I learned this to my bitter experience when I represented the Atchison, Topeka, and Santa Fe Railroad in a case challenging the federal government's impairment of a contract that the national railroads had been given when they set up Amtrak, and lost unanimously on the grounds that there's no contracts clause that applies to the federal government. It's just rational basis review, kid, get lost. So assuming no contracts clause, assuming no takings issue, how should this be treated as a matter of bankruptcy law? David has said, let's draw the distinction between funded and unfunded pensions and draw an analogy between secured and unsecured debts, treat funded like secured debt, treat unfunded like unsecured debt. Maybe. I'm not completely convinced that we have to be that generous. There are some distinctions between even funded pension benefits and security interests, as I mentioned. Certainly, I think if you had a defined contribution pension, that would almost certainly be regarded as a property right in bankruptcy. But a defined benefits pension in which there's just this pool of assets, undifferentiated pool of assets that secures payments, I'm not so completely convinced by it. It strikes me that, and I mentioned this to David earlier, that a possible analogy, and there may be some old cases that actually deal with this, would be an unsecured debt that has a sinking fund obligation. Sinking fund obligations were obligations, contractual obligations, where the bond issuer, the debtor, had to set aside certain money each year to build up a fund to pay off the bonds when they matured. There may be some cases where those firms went into bankruptcy, and maybe there's something to be learned about how those sinking fund bonds were treated. And that seems to me to be a pretty close analogy to a funded defined contribution pension, closer perhaps than a security interest. Fifth point, if David's right, and I think he's got a lot of common sense behind him, that the funded-unfunded distinction is critical here, then we're going to have a whole bunch of disputes about who decides how much of these pensions are funded. I mean, you may have read about some of this. You know, the employees and their representatives say, oh, it's almost all funded, you know. We have these assumptions, and they're reasonable. You know, the pension's going to earn 12% a year, and we're going to invest in all these magical investments, and so they're fully funded. So who's going to decide the reasonableness of these assumptions about what's fully funded and what's not? Presumably the bankruptcy judge. But this could give rise to lots of cantankerous dispute. Security interests are a lot easier. You just say, here, take the property, or else we'll give you the fair market value of the property. Figuring out what a funded pension is a little dicier. Okay, sixth point. David has a soft heart. He's a soft-hearted individual. At the end of his paper, he starts talking about how under a sort of no unfair discrimination analysis, we might even want to give these pension holders more for their unfunded pensions than we give to other people that we're not so concerned about, like bondholders and general creditors and so forth. I'm not so sure that's a good idea. I think that one reason we have bankruptcy, David would know better than I, but I think one reason we have bankruptcy is to sort of set down some pretty clear rules about how assets are going to be divided. And if you're in the same relative priority as somebody else, they should be treated equally. And to sort of open the door to say that we're going to start differentiating between creditors of the same class because, you know, oh, their pensions aren't that big, or oh, they don't have Social Security benefits, or oh, we feel sorry for them. Strikes me as it might lead to lots of, you know, squabbling, lots of appeals, lots of delays. And David's pitch today is, you know, we want these clear signals to employees. Maybe the clear signal comes if we say, you know, you're going to get treated just like the bondholders, the unsecured bondholders, and that might be more salutary going forward. The last point I'll make is this. It's instructive to compare how private pensions are treated versus government pensions. And I'm talking now about defined benefit pensions, not contribution pensions. Private pensions, the employer has to comply with ERISA, which has all sorts of provisions about funding and notice to employees and so on and so forth. Guess what? Public pensions are exempt from ERISA. Private pensions have to comply with the Pension Benefit Guarantee Board's rules and regulations, and the employer has to contribute to an insurance fund that will pay off these pensions in significant part if the company goes under. That doesn't apply to public pensions. So in the public area, we have managed to convince ourselves that the state and the local governments can be trusted to monitor their own behavior, and that the employees that are relying on these pensions will not suffer because the state is always interested in doing good, unlike private employers that need to be heavily regulated. And we now see the consequences. We see that, in fact, we can't trust Michigan to enforce these full funding requirements. We can't trust local governments to set aside adequate amounts of money. And indeed, the employees are going to be the big losers in this process. So I don't know how to reform the system. I think that if the Congress tried to force states into the ERISA or force them into the Pension Benefit Guarantee Fund, that might very well raise 10th Amendment issues. Unless the states consented to do that, and they might not consent to do that. One thought that occurs to me is maybe we could use the IRS. The IRS has regulations about when pensions are qualifying so that you don't have to pay taxes on them. Maybe they could beef that up and regulate the employees rather than the employer in the public pension context and try to build some more protections into public pensions that way, but that's just a random thought. I basically think that we have encountered a very serious problem with no obvious solution. Thank you.
So at this point, I think I'd like to give Professor Skeel and Professor Merrill a chance to respond to each other a little bit. Then I may take the privilege of the first question and open it up to all of you guys after that.
Great, thanks, Erik. So a couple quick responses to Tom's comments, which are, as always, just terrific and full of useful ideas. One is, I find the story about the contracts clause in the 1970s, states taking that and running with it, really, really interesting. The standard argument I hear about contracts clause issues is that we have reason to be more worried about states when they're a party to a contract than private individuals, because states have a self-interest in abrogating contracts or changing them, and therefore the protection should be tougher vis-a-vis states. But I really like Tom's insights into this. I'd love to hear more about that. Second, on the Supreme Court cases in the 1930s, Ashton in 36 and Beacons in 1938, the state consent issue, as I understand it, is actually the reverse. So that in the earlier municipal bankruptcy law, state consent was required, but in the later law, it was not required, so that state consent was not a basis for upholding the law in 1938. As of 1978, state consent was once again required. In Beacon's, the 38 case, the second municipal bankruptcy law, there's a line where the court says, we don't really think this makes a difference. There's some interesting implications of the difference in the consent requirements that I'm still working through. The key, as I understand it, with Beacon's and upholding the second municipal bankruptcy law was that it bent over backwards to not interfere with governmental functions and governmental and political functions, which the earlier law had kind of done too, but the Supreme Court really picked up on that. The third, Tom's arguments that maybe not even the funded portion is protected, that by analogy to sinking funds or to other somewhat similar arrangements where there is not a clear piece of property or clearly identifiable property the way there ordinarily is with collateral. I think that's really, really interesting. I think probably a court concludes there's a property interest in the amount that has been funded, the fund set aside, but I think Tom raises a really good point, and it's possible that there's not, because that funding is not identifiable in the way a widget is identifiable. And then, well, two more things really quickly. On the difficulty of figuring out who gets what, I don't think that's a huge problem, because in Detroit at least, there is an amount of funding that's been set aside, and we can just cut it off as of the bankruptcy filing and say the retirees get that funding, and that's what they get. They don't get more, they don't get less. So we don't really need to make make assumptions about investment returns going forward for the purposes of determining what the fund is. We may need to make them for the purposes of deciding who gets what, which of those retirees gets more and which gets less. And those are really hard issues, I think. But I think it's important to separate the pool of money issue, which it's very clear what the pool of money is, from the who gets what, which is much less clear. And then finally, Tom's points about things we might do to improve the public pension process, I think, are wonderful points. I like the IRS idea, and so these are all food for thought, I think.
Tom, do you have
Just very quickly, you know these cases better than I do, and you've read these statutes, so maybe I just was misled by, or maybe I'm just trying to defend Charles Evans Hughes because I'm the Charles Evans Hughes professor, but on page 27 of Beacon's, Chapter 10 of the Bankruptcy Act is limited to voluntary proceedings for the composition of debts. Later on that same page, it's unnecessary to consider the question whether Chapter 10 would be valid as applied to the irrigation district in the absence of consent of the state, which created it, for the state has given its consent. And then over on a couple pages later, we are thus brought to the inquiry whether the exercise of federal bankruptcy power in dealing with the composition of debts in the irrigation district upon its voluntary application and with the state's consent must be deemed to be unconstitutional interference with the essential independence of the state as preserved by the Constitution. So,
Okay. Do you want me to
Yeah, sure,
interrogate
yeah,
that? So,
yeah.
so all municipal bankruptcy statutes have been strictly voluntary, so that there's never been a municipal bankruptcy statute where creditors could throw the municipality into bankruptcy. That's what that first statement was referring to, the fact that it's voluntary only. The other quotations are all based, as I understand them, on the court saying, we don't really have to worry about the possibility that it might be unconstitutional to have if it's possible for a municipality to file for bankruptcy, even though the state does not consent, because here we have a state that is consenting. And so my reading of those two statutes, or those two cases, is, again, that the first one explicitly required state consent. The second one didn't, but the state had in fact consented, and so the court says it's not really an issue. But, I mean, we can sort that out.
Yeah, I mean, I read McReynolds' opinion in the earlier case is only mentioning consent, and very briefly at the end. And it's all about dual sovereignty and, you know, the analogy to intergovernmental tax immunities, and it's very much a kind of, you know, old-style formalist decision. And then the Hughes opinion seems to emphasize that there's consent here quite a bit. But
well, that the state, it clearly does emphasize that the state wants this. This is part of the federal-state partnership,
Right.
et cetera, et cetera. No question about that.
So the bankruptcy power is obviously larger if there's consent, right? You know, anytime you consent to bankruptcy filing, you enlarge the powers.
I oddly enough disagree with that in the context of states, right? I mean, it seems to me that this goes to the contract clause question a bit, and I'll throw that out as well. So if the federal government formally breached just using its superior authority, breached a contract between the state and a private party, that clearly is not a contract clause violation. It may be taken by the federal government, but clearly neither the state nor the federal government has violated the contracts clause. If the federal government says, you could breach the contract whenever you want, and then the state elects to breach the contract, that strikes me as a contracts clause violation, because it's done at the volition of the state, and the federal government is not empowered to authorize states to violate the U.S. Constitution any more than they'd be empowered to authorize them to enact a bill of attainder, to enslave people, or to any of those things, just because they are supreme vis-a-vis the state. And the other way to look at this is there's no conflict, right? The state can comply with both. The federal government is merely giving them authority that the Constitution then denies them. There's no inherent conflict there, hence no preemption. Not that there could be, obviously. The federal government can't preempt the Constitution, but even if you operate on that. So that's one question in terms of why this doesn't constitute a contracts authorization of a contracts clause violation that is then triggered by the state consenting to something they're not obliged to consent to. The second question I have, and I'll let you answer both of them, is I get that this is not a 10th Amendment problem, maybe, but I don't know that the takings issue has ever been litigated well enough to uphold municipal bankruptcies, given that the critical difference between municipalities and private parties is, A, they can't be involuntarily put into bankruptcy and liquidated, whereas a private party could, and consequently, and B, the state could quite frankly step in. I'm not sure if that, I guess that just begs the question once you move to a higher level, so the state goes bankrupt. But at the end of the day, there is no intrinsic reason why you couldn't get fully paid short of a complete collapse of the body politic. Which I guess at some point there might be, but we're talking about cutting off obligations well before the point where we think Detroit would disintegrate and literally everyone would move out and there would be no property left. So then you have the situation in private bankruptcy. No, in private bankruptcy, what you have is you have to get at least as much as you get in liquidation. Whereas here, you have to get at least as much as you get under a bunch of weird assumptions about what Detroit would be willing to do. So if you could tell me why that's not a big enough distinction to make this a taking, and also the contract clause authorization question. You got to toss that to you guys.
There's a lot in there, so yes. I'll take a whack, and then maybe Tom can take a whack. On the first one about is, as I take it, basically an argument that state consent, if you have a bankruptcy law where the state is consenting to a filing of municipal bankruptcy, you're facilitating a violation by the state of contracts within that state, and therefore it's a violation of the contracts clause. That was, as Erik I'm sure knows, at the heart of the 1936 decision striking down the original municipal bankruptcy law. And it's a plausible argument. The 1938 case says, well, it's not really the same thing, that there is a meaningful difference between the state doing it itself and the Congress getting between the state and those contracts, at least in the bankruptcy context. So I think the bankruptcy power has to be part of this discussion. But I do think there's an issue there. If there's an issue there, I think, again, that municipal bankruptcy is just unconstitutional. Like a friend of mine is arguing that the law that did not require state consent by its terms might have been okay under the Contracts Clause, but requiring state consent is not okay. In my view, even if you don't require state consent, if Detroit can voluntarily file for bankruptcy, that is a state entity making a decision to file for bankruptcy, so we're right back where we started. So if state consent is problematic, municipal bankruptcy is problematic, is my view. I think that argument loses, but I will not bet even my net worth on that.
As a predictive matter, I agree, but what do you think as a sort of a constitutional matter? I agree this court doesn't have the stomach to actually do anything that correct.
A technical argument here, which may not satisfy you, but after Ogden versus Saunders, it was pretty clear that state insolvency laws that are purely prospective do not violate the Contracts Clause. So I take it that from the perspective of the Detroit bankruptcy, this particular regime is prospective. This was all in place before these pension obligations were incurred by the city of Detroit. So actually it would not violate the Contracts Clause for the state of Michigan to impair these obligations, and therefore the federal government authorizing it through bankruptcy is not aiding and abetting something that the state doesn't have the right to do.
So you effectively read existing bankruptcy law into the contract itself, and hence, of course, there's no violation.
Right. That's a kind of an unsatisfactory technical dodge, but I mean the more interesting theoretical question, I was pulling out my Constitution to see how, there's Article 1, Section 9, which prohibits the Congress from doing certain things, and there's Article 1, Section 10 that prohibits the states from doing certain things. I was trying to figure out how many prohibitions apply to the state but not the federal government, so that you could raise this kind of, end run argument. The only one that strikes me is no state shall enter into any treaty, alliance, or confederation.
Well, that's with consent.
No.
Oh, it's not that the consent is only for later, for compacts.
Yeah, later they can enter with the consent of Congress. They can lay duties and imposts on imports and so forth, and they can do various things like interstate compacts and so forth. But there's no consent exception to no state shall enter into a treaty. So the hypo might be, suppose Congress passes a statute authorizing California to enter into treaties with whoever it wants to about climate change or something like that. Would that then violate this section of the Constitution because Congress is trying to give the state the power to do something they're prohibited from?
Well, and there's obviously 14th Amendment analogs as well, where Congress, while empowered to enforce the 14th Amendment, presumably is not empowered to waive it.
Mm-hmm. Right, but I still, it strikes me as a stretch to, bankruptcy is not exactly like authorizing somebody to engage in wanton impairments of contracts, and there's this technical response too. So
well, private bankruptcy isn't, only because the alternative is zero or some minimum that you get, and that is a taking. It's just a fully compensated taking. So you don't have a contracts problem there either. It's a contract that the best remedy you could possibly hope for is that.
But you think state contracts are different because the state could always scrape deeper into its pockets and come up with the money?
Yes.
Well, I would make that argument in a different way. I think it's a good argument, but the way I would make the argument is in an ordinary bankruptcy case, there's a requirement that every creditor be given at least as much as they would be given if this company were just liquidated. It's known as the best interests of the creditors test, and Erik, I'm sure, is familiar with it. In municipal bankruptcy, we have best interest of the creditor's language. We have a provision that says the plan must comply with the best interests of the creditors, but nobody's exactly sure what that means because cities can't really be liquidated. And so a fair amount may turn on how that's interpreted. If it's interpreted to mean Each creditor must be given as much as they realistically would get if there were no bankruptcy and Detroit further imploded. That probably satisfies your taking concerns in the same way that ordinary bankruptcy satisfies your taking concerns. But if it's applied more loosely, as some people argue it should be, to say something like the plan is a pretty good alternative to what there would be out of bankruptcy, then it starts to be a little bit more worrisome. I agree with you about that.
Can we turn it to the audience now? And there should be a,
I don't know if we can move this podium or not.
I don't know, but I can do that while somebody with a microphone goes around. I think start there. We'll bring it up here in a
I'm
second.
just moving it so that people aren't blocked. I think it's all right if we get it there.
Are you ready?
We're ready.
All right. I have two questions, but I'll be a good citizen and just ask one right now for Professor Skeel. It struck me that with many of your arguments, with the exception of the state constitution, they could equally be applied to the municipal bondholders. After all, they have a contract with the state also.
Absolutely.
And as a result of that, I really was dissatisfied with this last colloquy that they're suggesting that there is any alternative to the scheme that you're proposing and to allowing Chapter 9. In other words, if this isn't allowed, you can't do anything with the pensions, you can't do anything with the municipal bonds. That simply doesn't make sense, and the suggestion that you can't have a constantly eroding tax base, which will remove the viability of the city, doesn't square with my understanding about how rational people act. So for that reason, I think you might address that as to whether you've considered that, not just your excellent arguments about pensions, but also the interplay with the bonds and with whether there is, in fact, any reasonable alternative other than following this approach.
It's a great question. Should I go ahead and give an initial answer? I mean, I have thought about this some. I don't know if you have alternatives in mind that you can imagine. So I'd be very interested to hear that. So I may have misspoke a little bit. What the assumption I was starting from is that some kind of restructuring is probably better both for the city and ultimately for creditors as a whole. Maybe not for one particular creditor, but for creditors as a whole, than the absence of bankruptcy when everything just collapses. And people do have remedies. There are assets in Detroit. And we can't be exactly sure how that plays out, but it's not obvious to me that's better than a bankruptcy where we can restructure. So that's one thing I would say. There may be other alternatives you have in mind that I haven't thought of. The other thing I'll throw out is the bond issue is really, really interesting. I mean, both of these issues are really, really interesting and difficult. And one of the reasons the bond issue is so difficult is there is a difference of views between the bond world and the bankruptcy world as to what the status of those bonds are, particularly general obligation bonds. The bond markets, the muni bond market, thinks that those are really well protected bonds and that the full faith and credit of the state is behind the bonds and they're as protected as you can be. That is not what their status in bankruptcy is. Those are unsecured obligations, almost certainly in bankruptcy. And so there's this really difficult and interesting clash of worlds where the muni bond markets think these things are protected and they're not, and they're waking up to this. I do think there's room for some distinctions in bankruptcy of the sort that Tom doesn't like, and I can understand why he doesn't like it, but I think there is room in Chapter 9, in the particular mechanics of Chapter 9, to say a general obligation bond that's been approved by voters warrants a little less of a haircut than a bond that hasn't been approved by voters. I think there are arguments to the contrary, but I think you can make an argument that these are not exactly the same instruments and it's not discriminating unfairly to give them a slightly different payout. But there is this culture clash between the muni bond market and bankruptcy. And part of it is because the muni bond market is just used to assuming there'll be a bailout if any city or state runs into trouble. But part of it is honest beliefs about the status of bonds that from a bankruptcy perspective are almost certainly wrong. Not working.
This question's for Professor Skeel. You had mentioned that after the Ashton decision, there was some language that essentially bent over backwards to accommodate states' rights, and I believe you're referring to Section 903 or Section 704. In Re Valeo 2009 chapter, or 2009 Chapter 9 case, there's a constitutional analysis that goes through the Contracts Clause, the Supremacy Clause, and the 10th Amendment, and says that where a state has authorized or given consent to its municipalities to file Chapter 9, at that point, all of the bankruptcy-specific provisions of Chapter 9 apply in full, and that any state law that seeks to kind of cut back on those would be unconstitutional, would be preempted by the Supremacy Clause.
Interesting.
So in Valeo, they use that analysis to void collective bargaining agreements as executory contracts. Do you agree with this analysis? And if so, what bankruptcy-specific provisions would allow for the adjustment of vested pensions?
So I'm going to answer the question up to the vested part, and then I'll try to answer that as well. So I had forgotten that Valeo talks about that. This is really interesting. I do need to go back and reread Valeo. I do agree with that analysis. The analysis that when a state consents, they're consenting to bankruptcy provisions, not to non-bankruptcy provisions. This is really important for the purposes of the pension issue, because one of the arguments against restructuring pensions is an argument that, well, a bankruptcy restructuring couldn't violate the freedom of speech or the freedom of religion. It can't violate all those things in the Constitution, so why can it violate another provision that's in the Michigan Constitution? You know, if it can't violate freedom of speech, why can it interfere with a provision that says pensions are fully protected? One answer I have to that is simply that I think that's misunderstanding what that pension provision is doing. But even if you are of the view that that provision says pensions cannot be messed with at all, messing with pensions is a distinctively bankruptcy task. Restructuring a pension, restructuring a bond, dealing with executory contracts is something that bankruptcy is about. So that's right in the heart of the bankruptcy clause. Interfering with freedom of religion or freedom of speech is not what bankruptcy is about. So I think the Valeo decision, I'd forgotten that it talks about this. I think from the way you've described it, it strikes me as just right. On the vesting issue, I see that, I keep trying to draw this distinction, and it's not as crystal clear as I would like it to be, but between the promise and the priority. So the commitment to a pension on the one hand, the promise, and on the other hand, the priority. I see vesting as relating to the promise. And so until your pension has vested, this is not a promise that we're going to actually pay you the pension. So it's a little bit like saying there is a point at which this promise becomes an actual contractual obligation. That's what vesting is about. I think in Michigan, it's sort of an automatic, immediate vesting. I'm not sure, and there may be different rules in different municipalities, but that's how I see the vesting issue. I see as that is going to the promise, not to the priority issue.
You have a question over here?
On this point about the defined benefit plan being a secured debt to the extent it's funded, and this could be for either Professor Skeel or for Professor Merrill. So, assuming the Detroit defined benefit plan is a tax qualified plan like it should be, there is one Internal Revenue Code rule that applies that says that the money, once it is contributed to the pension trust, can only be used to provide pension benefits until the day comes, if ever, that the trust's obligations to the employees is completely extinguished. So I think they call it the exclusive purpose rule. So if there is money in the trust, even if it's only 60% funded or whatever the number might be, does the fact that there's an Internal Revenue Code rule that says that money can only be used for the retirement purposes, does that maybe bolster the argument that that's secured to that extent versus unsecured to the extent it's unfunded?
Yeah, I think it helps. I mean, the secured, unsecured debt is an analogy. It's not I don't think the argument is that this maps perfectly onto that distinction. But the more you could show that there is a discrete pool of assets, bonds, and stocks and so forth that can only be used for satisfying this one type of obligation, I think it begins to look more like, and it begins to look more like a defined contribution pension, which I think looks more like property, and so it begins to look a little bit more like a security interest, which looks a lot, which is definitely property. Yeah.
Do we have other questions? Second question, you can see. Your patience paid off.
Virtue rewarded.
By the way, it's a total aside. My friend and I were a little curious about, this isn't my question, about how you were able to offer a free lunch. Who's sponsoring this? Okay, now here's my question. This is for Professor Merrill. You know, I like that, since I'm a big believer in municipal bankruptcy and how it has to go through and any workout is in anticipation of bankruptcy, I then take it to the next level, and you were talking about reasonable expectations and what are they really going to do about this in the end. And I wonder if you have looked at the Detroit situation or the other Chapter 9s in contrast to the General Motors bankruptcy, and have we done such destruction to expectations or normal, regular order, you might say, in General Motors that, you know, one is very concerned and scared about what's going to come out here?
Yeah, David probably knows more about it than I do, but I was consulted briefly on General Motors by the bondholders. Chrysler was the worst case, right? Because there were secured bondholders that took a haircut so that the union trust fund could get some compensation out of the bankruptcy. In General Motors, it was just general obligation bondholders versus the union, and the union got a leg up there. Now, my understanding is that the legal justification for this is that these are 363 sales. The federal government was providing the financing, and so, you know, the piper played the tune, and the dancer had to dance to the tune of the piper. And the bondholders, I mean, I gave them some arguments for why this was an outrage and so forth, violates the uniformity requirement of the bankruptcy code. But they concluded that basically it was just too risky and that they were going to get more if they went along with this deal, however odious it was, than if they continued to fight for what they thought their legal rights were. So I think that was a very nasty precedent. Even though it was technically in the 363 sale and therefore not straightforward, reorganization determination by a bankruptcy judge. And Dodd-Frank, which unfortunately I know a little bit about because I was looking at some of the constitutional issues under Dodd-Frank. Dodd-Frank, has this provision that says, all creditors of the same class shall be treated equally, except when the receiver decides that in the interests of systemic, financial health, it's necessary not to treat them equally. And so there's, quite a bit of people are scratching their heads and saying, what on earth does this mean? Does this mean, that now when we have one of these Dodd-Frank orderly liquidations, that the receiver, who's sitting there talking to the Treasury Department, who's talking to the White House and so forth, can just basically decide that we like this creditor, we don't like this creditor, and it's all necessary in order to preserve the financial health of the United States? I mean, I think, yeah, we are heading down this path.
Can I add a footnote to Tom's? I agree completely with Tom's characterization of Chrysler as a problem, General Motors as less of a problem. I mean, with General Motors, the government bought General Motors. If you pay $50 billion, you could have had General Motors too. But in Chrysler, they really did, I believe, rip off the senior creditors. But it's a sort of complicated argument along the lines of what Tom said. But it clearly is shaping the way people are thinking about these cases. And for instance on this that you may well be aware of is right when Detroit filed for bankruptcy, there was a state court judge that said this bankruptcy has to stop. It's a violation of the Michigan Constitution. And the judge said that she believed the Detroit bankruptcy filing disrespected the car bailouts and the administration, and therefore it couldn't. There must be a way to bail out Detroit. And so there is a little bit of this now. I think kind of if there's a will, there's a way. Regardless of what the specific rules say, that is kind of worrisome. Although So far, I think the judge in Detroit has been pretty good. I think he seems to be a pretty no-nonsense judge, so I'm cautiously optimistic about where Detroit is headed.
Hi. Is there a way we could limit New Jersey Trust in terms of how far it provides?
Just here. The camera's right behind you.
Okay.
So look into the camera.
Okay. Is there a way that one could limit the reach of New Jersey Trust, which created this whole special protection for public as opposed to private contracts, by saying that it didn't involve obligations to public employees who in other proprietary contexts receive less protection than many other parties? Like by analogy, in the First Amendment context, you can regulate what a public employee says that's not a matter of public concern. But in other proprietary contexts, like state university students, you cannot regulate what a university student says merely because it's not on a matter of public concern. Under court decisions like Garcia and Pinard, federal appellate decisions, suggesting that even within the proprietary context, the government gets a freer hand in dealing with its own employees than it does other parties that it interacts with in a proprietary basis.
That's interesting.
I mean, I think what happened was this, that the Supreme Court, a majority of the justices on the Supreme Court thought the contracts clause was a mistake, and that it should all be watered down to rational basis review, like, equal protection and due process challenges to social and economic regulation. And they were headed in that direction, and then they got this New Jersey Trust case, which involved municipal bonds. And, Justice Blackmun, who, knew something about municipal bonds and so forth, said, wait a minute, we can't have the municipal bond market tank because, it's all rational basis as to how you fiddle around with, indentures and promises made to bondholders. So the solution was to create this two-tiered standard of review where, government promises get a higher standard of review than, private promises do. But they were thinking about bonds. I don't think they were thinking about pensions and some of these other things. But there was the state courts that then ran with this in order to ratchet up the protection for pension obligations, which of course is exactly what the state employees and the state unions wanted, and so we're stuck. I have an old article. I don't like to flog my own work too much, but it's in the Case Western Law Review, 1986 or something like that, that attacks this two-tiered standard, and I think takes in all the arguments about how you can distinguish between public and private, and at least back then I thought I demolished them. And my argument was we should just go back to treating public and private contracts the same way. That's sort of the way they were treated throughout most of the 19th century.
Could you limit the cancer by saying that they get an especially free hand in dealing with their own public employees as opposed to bondholders, the way that in the First Amendment context, there's different classes of people and how much rights they have against the government in its proprietary capacity, the way a public employee gets less rights than like a state university student? Does that make any sense?
So you'd be flipping the priority on its head, basically. I mean, so rather than treating state promises more strongly, they would be weaker, at least in this particular context.
In the Dormant Commerce Clause, ironically enough, you have the opposite situation where the state gets an extra free hand in the proprietary capacity, where it's exempt under Reeves versus Stake from these constraints that would apply in the regulatory capacity. But I don't think you need to go that far. You could just say that bondholders are a different category of entity than public employees for purposes of their proprietary powers.
Yeah.
They were brought in under Waters versus Churchill in cases like that to regulate what their own employees do, because in a sense the public employee is the hands and feet of the government itself, whereas the bondholder isn't.
I mean, there's a number of levers here. One is, finding a contract in the first place. Bondholders have these very elaborate, very explicit contracts. There's no question, but they have these indenture things or contracts. Public employees frequently, it's some kind of statute, that makes various provisions about, when you can retire and, when your pension's vested and so forth. And the employee signs up, and maybe there's a contract, but usually there's not a written contract. So you could just say that under the standard, notion that government contracts are not likely to be presumed to exist, based on statutory language, that, a lot of these employment things are simply not contractual. Now, I take it in Michigan you can't make that argument because it's in the Constitution, the state constitution. But you could do that in many states. And the other thing is just this sort of police power justification, which I think is somewhat unfortunate. But there is this exception to the contracts clause that if there's some kind of police power justification for regulation that can override a contract. And maybe in the employment context, you've got so much more going on in terms of the interaction between employees and the public and so forth, that there's more of a police power justification for flexibility. Whereas with bondholders, you're dealing with, international credit markets, and you have to sort of play it straight. I don't know, something like that.
So
Yeah.
apropos of the Detroit Constitution, I'll take the privilege of another question. So I noticed in your paper where you said that Michigan courts had basically held that unenforceable for all practical purposes. Putting that aside, if there was a constitutional violation that just hadn't been litigated and won yet, where would such a chosen action sit in bankruptcy? And to give you something to compare it to, if the day before it declared bankruptcy, Detroit went and took your car, or took your bank account, a straight up taking, and you just hadn't filed suit yet because they declared bankruptcy the next day, where does your chosen action for a blatantly unconstitutional taking stand relative to bankruptcy law? Is it just an unsecured chosen action?
Claim. Yeah, too bad.
So a constitutional violation where they take my car, it's not secured, of course, because
Yeah, I'm not so
I
sure
didn't
about that.
voluntarily
I
give them my
think-
car.
I think I would have an argument that the Detroit or whoever the bankruptcy debtor is doesn't have any ownership interest in my car, and so I would think I can get that back.
Well, they have a right to take it if they give me just compensation. So really, at the end of the day, as long as they're willing to give me just compensation, they do have a right to it. But they've given me nothing and now declared bankruptcy and decided just compensation is 10 cents on the dollar.
So if you overrule the second half of Williamson County, nobody in this room is going to know what I'm talking about at this point. You might be able to go straight to federal court in a 1983 action if it was clearly a taking by the state, and that you wouldn't have to exhaust state remedies and get it decided in federal court. I would argue you ought to be able to do that, yeah.
And so related to that, so why is it that the Detroit constitutional provision is unenforceable? Why can't you just enter a judgment saying you owe $1 million to the pension fund, like you owe $1 million to the kid on the corner you beat up in violation of the Fourth Amendment? 6 of one, half dozen the other. It's just a judgment. Why is it that it's unenforceable?
I'm not following the question anymore.
So-
I mean, one thing.
Michigan's held that we can't make you put the money in that you should have put in for your pension obligation. And your point was, had they put in more money into the trust fund, had they complied with their constitutional obligations, it'd be at least more funded, if not fully funded.
Okay.
Courts have always been more skittish about ordering governments to pay money than ordering them to stop doing stuff.
Well, but I'm just talking about the traditional, cop
I'm
on the
ju- I'm
corner,
ju-
beat some kid up.
I'm just
gets
talking
smacked.
realpolitik now. So
Yeah.
ordering the state of Michigan to raise taxes to pay for Detroit's mess.
They don't have to raise taxes. It's just a judgment. You pay for it however you want,
Well, okay. What are they going to do?
like any other judgment against. You don't have the money to pay for the kid you beat up
Maybe
on
they
the
could
corner.
start fracking, or something like that. But
Well, but I'm just saying. But the question is, why wouldn't they? What was the rationale for refusing to enter a judgment, aside from the question of how you'd enforce that judgment?
And I no longer know what judgment you're
The
talking
judgment that
about.
says Detroit owes $10 million.
Maybe, why don't we take this
Yeah.
outside? This is getting a little.
no, that the state of Michigan has to pay the money. That's what I'm asking.
we have the-
Oh, is that what you're
You
saying?
got it.
Yeah,
Oh,
the-
good. Okay,
the
good.
hypothetical was a sort of
I'd
indirect
rather go
way.
back to the audience. So please go ahead.
So going back to the question of how to keep pensions funded in the future going forward, I also really liked Professor Merrill's idea of the IRS going through the back door and the federal government regulating it because they've got ERISA and they've got the PBGC. It seems like they have it more together. But in general, we don't want the federal government to have to swoop in and tell states and municipalities how to do things. So is this an exception to that general principle? And if so, why?
Yeah, that's a great question.
Yeah, another point that might be made here is that I don't think it's entirely an accident that as soon as ERISA got passed and implemented and the PBGC got up and running, private employers started leaving defined benefit pensions in droves and starting with defined contribution pensions because they didn't want the hassle of these regulations and all these insurance funding requirements. So if we backdoored it through the IRS for the states by regulating the employees rather than the state governments themselves, the states may just respond by starting to have defined contribution pensions for state employees. Now, maybe that wouldn't be too bad. They'd be on parity with private employees in that regard. But there's lots of interacting parts here, I think, that are hard to anticipate in advance.
I was just curious if it had any impact at all, the fact that Detroit's bankruptcy was forced on it by the state over the local city leadership?
Well, it certainly had a practical impact. I mean, Detroit would never have filed for bankruptcy if its city council and mayor had not been replaced by an emergency manager under Michigan's emergency manager law. So certainly, as a practical matter, would we have had a bankruptcy? No, I think almost certainly not without the emergency manager being in place. So I don't know that if that's your specific question, but
If there's any legal impact to the fact that the municipal leadership would be opposed to any type of haircut.
so not necessarily, although there are arguments that the emergency manager provisions are unconstitutional, that they violate contracts. And one of the arguments against restructuring pensions is based on the emergency manager statute as well. So there are some of those arguments out there. The emergency manager laws allow the emergency manager to terminate collective bargaining agreements, and there is a nice question, I think, as to whether that's consistent with the Contracts Clause of the U.S. Constitution. The provision is drafted with the jurisprudence in mind. It's drafted to say you can only terminate an a collective bargaining agreement if there's a serious financial problem and there's no other realistic alternative, which is designed to plug into the U.S. trust and the other case law. So yeah, there are the emergency manager provisions. There are a bunch of issues that arise out of them, and some of them do overlap the pension issue.
Great. Well, I think that wraps up our panel for today. Thank you, Professor Skeel, Professor Merrill, and thank you all for coming, and good questions. Thank you.